All right, if you're gearing up for the bar exams, there's one area of the federal court rules you have to know inside and out, and that's Part 16. Think of it as the architect's blueprint for your entire case. Seriously, if you get this part wrong, the whole structure can just collapse. But if you get it right, you've built a solid foundation for a win.
And I'm not exaggerating here. Long before you ever step foot in a courtroom, long before you say a single word to a judge, your very first, and honestly, your most critical battle is fought on paper. So the real question is, are your pleadings actually built to win? Let's dive in and find out.
So, before we jump into the nitty-gritty of drafting, we really need to get our heads around why pleadings matter so much. I mean, what is their fundamental purpose in the federal court anyway?
At its heart, a pleading is the formal document that literally defines the entire battlefield. It's not an application, and it's definitely not an affidavit. It's the official map of the dispute. It tells the court, and just as importantly your opponent, exactly what issues need to be decided.
You can actually see how these four purposes create a kind of logical chain. It all starts with defining the issues with crystal clarity. That, in turn, ensures procedural fairness, no ambushes, no nasty surprises down the track. And once those issues are set in stone, you know exactly what evidence is going to be relevant. The whole structure is designed to serve that ultimate goal, attaining justice.
Okay, so we've got the why, now let's get into the how. This next part is basically your essential checklist for drafting a powerful, compliant pleading that's going to stand up in court.
First things first, Rule 16.01, and this one is absolutely crucial. When you, as a lawyer, put your signature on a pleading, you're not just signing a form, you're giving a personal professional certificate to the court. You're saying, I've reviewed the material, and there's a proper basis for every single allegation in this document. It's a cornerstone of your ethical duty under Rule 16.01. Now for the big one, Rule 16.02, Subrule 1. This is your positive checklist. You need to burn this into your brain. Under Paragraph A, use numbered paragraphs for separate allegations. Easy. Under B, be brief, no waffle. Under D, and we're going to come back to this one, you state the material facts, not the evidence. Under E, you have to state any statute you're relying on. And finally, under F, you have to tell the court exactly what you want, the specific relief you're seeking.
Right, I said we'd come back to it, and here we are. Rule 16.02, Subrule 1, Paragraph D, Pleading Material Facts. This has been called the most fundamental rule of pleading, and for good reason. It is the absolute, undeniable heart of your document.
So the whole game here is understanding this distinction. A material fact is the what. It's the essential ingredient you need to make out your cause of action. Think, the defendant breached the contract. The evidence is the how you'll prove it. The email, the witness statement, the smoking gun document. You plead the what, never the how. If you start pleading your evidence, you are doing it wrong, and you're just begging for that part of your pleading to get struck out.
Okay, so we've covered the do list. Now it's time for the don't do list. And this comes from Rule 16.02, Subrule 2. Think of this as the list of traps and landmines that can get your pleading thrown out of court. Now here's a critical connection you have to remember for your exams. These prohibitions under Rule 16.02, Subrule 2, are the exact same grounds for a strikeout application under Rule 1621. So if your pleading is scandalous, or evasive, or, and this is a big one, if it fails to disclose a reasonable cause of action, you haven't just broken a rule. You've literally handed your opponent the weapon to destroy your pleading entirely.
Let's just pause for a second on that word embarrassment. Now, in the real world, this means making someone blush. In law, it's a term of art. A pleading is embarrassing if it's so vague or confusing or all over the place that your opponent has to guess what case they're supposed to meet. And forcing your opponent to guess, well, that's a fundamental breach of procedural fairness.
And all of this leads to one of the most important doctrines in civil procedure, the idea that, generally speaking, you are stuck with the case that you put on paper. This principle is everything. You simply cannot plead one case and then show up at the trial and try to run a completely different one. And why is that? Well, it all comes back to procedural fairness. The other side has a right to know from your pleading the precise case they need to meet. Your pleading draws the lines on the battlefield, and you have to stay within them. But it's important to know that the courts have evolved on this. The old, really rigid view, where you were strictly held to the literal letter of your pleading, has softened quite a bit. Today, with modern case management, courts are way more pragmatic. They see pleadings not as an end in themselves, but as a means to attaining justice.
The principle is still there for sure, but its application is way less technical than it used to be.
So what happens when new facts emerge, or your case strategy changes? What if you realize you've made a mistake? Well, that brings us to our final section, amending your pleadings.
But hold on, you don't just get a free pass. You can't just rewrite your case whenever you feel like it. You need the court's permission, what we call leave, to amend your pleading. And the court is only going to grant that leave if the amendment is actually necessary to resolve the real issues in the dispute.
So when you ask for leave, the court is going to weigh several factors. How late are you in making this application? What's your excuse for the delay? Will the amendment cause an injustice to the other party that can't be fixed with a simple costs order? And, crucially, is the amendment futile? The court won't let you amend a pleading just to add a claim that has zero chance of success. The simple takeaway here is this. If you think you need to amend, you apply at the absolute earliest opportunity you can. Delay is your worst enemy.
So let's wrap this up. I want you to remember this. A pleading is never just a technical document. It is your first and maybe your best chance to advocate for your client. It's the story of your case. So the question you have to ask yourself isn't just, does it follow the rules? But is the story I'm telling clear, is it compelling, and is it built to win?